Salutations, respected viewers. This is George from Ireland. I'm continuing my series about common law. So this is an introduction. It's aimed at beginners, partly for the excellent reason that I'm not capable of doing something to a high level. Right, I'm going to look now at judges making law. We've already seen how there can be statute law, but this is a more tendentious topic. Can judges make law? Some people believe that the judiciary can make law. Others who say no, legislatures, they make law and judges simply interpret it. Well, judges are qualified lawyers, either barristers or solicitors. I'll look at the career pathways in another video. And then they are appointed to the bench. That's to say they become judges after at least 10 years practice. There are some very low-level judges in the criminal division who are magistrates, who are lay people, as in they're not barristers or solicitors, don't have a particular legal training, and they are reasonably educated people. Well, they certainly have A-levels, at least. Usually they have a degree in something. I knew, let's say, a radiographer who did this. It could be a dentist or a teacher or people who do just about any occupation. Tend to be white-collar occupations. Police officers are some of the few people who can't do it. Anyway, that's by the by. Judges should be politically independent. They're not actually forbidden from belonging to political parties, but in practice they very seldom do, and it's thought to be unseemly for them to speak out on political issues. Even if a politician monsters a judge, the judge will not respond. I remember the Abdul Basit al-Megrahi case. This Libyan who was convicted of the Lockerbie bombing, who was released early by the Scottish government in 2009. And there was also rumours going around that al-Megrahi was innocent, even though his conviction had been upheld, and the judge wouldn't say a word about that. However, Mingus Campbell, a Liberal Democrat politician, I suspect a friend of a judge, spoke out and said, hey, the man was convicted of murder. That conviction is still valid. That's it. Anyway, whereas the judge would not weigh in on such a tendentious issue. So they don't actively engage in politics. They're not allowed to stand for election. And they're people with excellent legal credentials and should have a reputation for probity. Caesar's wife must be above suspicion. Well, I shan't go into the appointments procedure. It's not like for Judge Kavanaugh. So judges sit in courts and they hear cases before them. They make rulings which are consistent with precedent. However, they're always alive to the possibility that a new situation may have emerged, and if there's some overriding reason, they may need to break with precedent and set a new precedent. When judges make a judgment, they stage their ratio decidendi. That's their reason for deciding. That's one of the Latin phrases you'd learn. Whilst summing up their judgment, they may make some obiter dicta, which are other remarks in this statement, but don't actually form part of the ratio decidendi. And the plural of ratio decidendi is rationes, as in reasons for deciding. So the various tiers of judges, that's got ranks and tiers of courts, as in tiers, a third in French, not tears from your eyes, T-I-E-R-S. Well, there are more than three of them, actually. So in the civil division, the most junior judge, he's in charge, or she is in charge of a county court. There's more than one court for each county, despite the name. And in each courthouse, there may be several courtrooms and several judges operating on any given day. If a judge is regarded as being successful in his or her job, then he may be promoted to a higher court. Remember, it can be he or she. And then they can move up to the Court of Appeal. Therefrom, they can go to the Supreme Court. This is a Supreme Court for the whole of the United Kingdom, not just England and Wales. So there'll be at least one judge from Northern Ireland and at least two from Scotland. When I say that, from Northern Ireland, he or she doesn't actually have to be born there, grow up there, but in that legal system. In practice, they always have been from there. Likewise, judges from Scotland don't actually have to be Scottish in any sense, so long as they're judges in that system. A judge from England or Wales doesn't actually have to be English or Welsh in any wise, but simply that they were in that legal system practicing. So prior to 2007, there was no Supreme Court as such. The highest court in the United Kingdom up until that time was the House of Lords. When I say that, it didn't just mean anybody in the House of Peers, the hereditary peers, the Lords spiritual, as in bishops and archbishops of the Church of England, or the life peers. No. This meant only the law lords, only the judges in the House of Lords. They were about 12 most of the time. So in the law reports prior to 2007, you'll see very frequent mentions of the House of Lords handling legal cases. And this does not mean that retired politicians or these peers of the realm were dealing with cases. Only the judges in the House of Lords, or the Judicial Privy Council, the Judicial Committee of the Privy Council, to be more accurate. Judges can make law, but this is tendentious. Some people complain this is judicial activism, and they claim that the judges are giving vent to their political prejudices, and they are straying into the political sphere, and that's unbecoming, just as it would be wrong for a politician to intrude into the judicial sphere. There are various schools of thought on how much judges can make law. They're known as the golden rule, the mischief rule, and the literal rule. But I won't delve into that. That's probably too much detail for the moment. So there's an ongoing discussion about the degree to which judges can create law. Some judges take the literalist view, which is say they must stick absolutely literally to what the legislation says, even if this produces a ridiculous result. There was a 19th century case, and some man, he'd bitten off somebody else's nose, and there were various laws like the Offences Against the Person Act saying you can't slap or punch or kick or stab or that, but it didn't actually say anything about biting. So as this wasn't specifically forbidden, the judge said, well, that's it. There's no crime. Not guilty. Free to go. Now, that may be an absurd outcome, but that is not for the judge to sort out. If Parliament frames the law that way, that is the law. If Parliament wishes to change the law, that's up to them. The judge is not going to fill in the blanks like that. The others say the mischief view, see what mischief to the nation this law was intended to resolve, and then to be a little bit creative in supplying the blanks. And the Acts of Parliament will often say what their purpose is. This is an act for the purpose of blah, blah, blah. The full name of an Act of Parliament was actually often as long as your arm, but they're usually known by the short name. It gets more complicated because they're known as the whatever year, the first year of Elizabeth II isn't past the first year of her reign. It might be the 11th Act passed in the first year of her reign or something like that, as well as being known as the whatever Act. So the judges will read the statute and see what mischief to the public this law was supposed to obviate, and they interpret statutes in the light of that. So the literalists are different. As I've said, they're applying the law as it appears in black and white, even if that leads to a preposterous result. If there's an anomaly in the law, it is Parliament's prerogative alone to rectify that, and the judges shall not stray into the political field. Then there's a thing called equity, which emerged in the Middle Ages. As I said, the law was too hidebound by precedent or sticking too precisely to the very words of legislation and not providing for situations which had arisen. And there was an adage which arose, I will not suffer a wrong to be without a remedy. So the judges became a little bit creative. They were reluctant to do so. They did not wish to overstep the bounds of propriety. Their role is judicial and not legislative, because they are legal, judicial, not political, which is why they refrain from entering into the political forum and making any controversial utterance. So they're supposed to be neutral above the political fray. So if a case comes before a judge and he or she may be regarded as having an axe to grind, then this judge should recuse himself. Recuse means to withdraw. There's this very well-known legal maxim, which is hore with age, nemo iudex in causa sua. Nobody may be a judge in his own cause, more like his own case. So if I'm a judge, if I'm in any way involved, I can't be the judge. If my sister's on trial, no, I can't do it. If my cousin is supposedly the victim, no. If my friend is suing on a contract, no. Or if I own shares in the company, which is in the case, no. In any of these cases, no. Now, it's possible that I might render a fair judgment even so, but there will always be the suspicion that I was prejudiced. So Caesar's wife must be above suspicion. So if they have any financial interest in the case, the judge must recuse himself or herself. And if he didn't, and if it came to light, well then the result could well be overturned. The case had to be heard again before a different judge. Lord Hewitt was a judge who in 1928 famously said, justice must not only be done, it must be manifestly and incontrovertibly be seen to be done. Because it's possible that the judge might rule fairly in such a case, but there would always be the accusation that he or she was partial, and they must be unbiased. The judge could be so eager to avoid being accused of prejudice towards his friends or relatives that he might actually lean the other way and be prejudiced against them. So judges mustn't have any financial relationship with those involved in the case. That includes having lent money to them, receiving a gift from them, things like that. So political neutrality does not go to ridiculous lengths. If a member of the Liberal Democrats is hearing a case of car theft and the accused is a member of the Conservative Party, the judge will still be allowed to proceed. Does this undermine the neutrality of the judiciary? Possibly. What do you think? I spoke to the judge about that, so, well, you've got to come from somewhere. So in Northern Ireland, many judges were members of the Unionist Party of the 1970s, and some judges were members of the Orange Order, which is a Protestants-only organisation. And some of those accused of seeking to overthrow the state by force were Catholics. So the impartiality of the bench was held to be doubtful by some people. What do you think?